To give you an idea of the size of the amounts that we're talking about, remember we're talking about a $4 billion loan. And here you can see that the amounts of interest paid from 30 November 2010 all the way through to 31 December 2015 was 194 million, 16 million, 197 million, and ultimately $1.032 billion in interest, and that was also the reduction that was claimed. Initially, they claimed much less because they thought there were some new UK anti-abuse rules which stopped them from claiming this deduction. But then BlackRock went all out for it. They met with HMRC and they said, we're going to do this deduction, and this is what they've done. HMRC's reaction was, as expected, not good. It said for each of these returns, the numbers that we just looked at, the closure notices, so HMRC asked questions and then came with a closure notice, concluded that no amount of the interest payable or the finance charges or the payment to vary the terms of the loans or notes or other finance costs is deductible for UK tax purposes, and no amount may be included in the non-trade deficits arising in loan relationships as recorded on the company's tax return for the period, right? And then point 34, HMRC reached its conclusions and made the amendments on the arguments that the NTLR debits, so these interest payments, are attributable in full to loan relationships that have an unallowable purpose, so therefore they cannot be deductible within the meaning of Section 441 of the Corporation Tax Act, and alternatively, loan relationships that gave rise to the NTLR debits are provisions within Section 147 of the Taxation Act of 2010, and those provisions differ from arm's length provisions. So the interest was not, well, it either had an unallowable purpose or it was not at arm's length. And if we look at the first tier tribunal analysis of this case, I'm not going to spend too much time on the first tier tribunal other than to get the facts. It says it is clear from the evidence of the experts that the transaction that was actually entered into would not have taken place in an arm's length transaction with an independent lender, right? Because there's all kinds of things wrong. So there was high uncertainty about when dividends would be paid from LLC 6 because LLC 6 could decide for itself if and when it did so, and LLC 5 did not control the board because LLC 4 did that, right? And then there was also this weird relationship between the contributions made of LLC 5 versus LLC 4, even though the court doesn't mention that at all. It is therefore necessary to hypothesize a different transaction which independent parties would have entered into. And this is an interesting sentence, right? So the court says this transaction is economically irrational. That's basically what they're saying, right? And now we have to replace this transaction with another. As it is for LLC 5 to displace the closure notice and amendment made to its self-assessment, it can only succeed on the transfer pricing issue by positively establishing that there is a hypothetical transaction in which a hypothetical independent enterprise would lend $4 billion to LLC 5. Now, the judge here looked at the pre-2010 transfer pricing guidelines. So this was a time when you could recharacterize a transaction. You know, if it wasn't possible to calculate the price of the loans otherwise, and these loans were not seen among third parties, right? So those were the two criteria. It was before the BEPS action and the 2017 guidelines, where we talk about that you first need to accurately delineate the transaction, and then you can replace the transaction if it is economically irrational or commercially irrational, I should say. So the court then follows the expert the witnesses and the Queen's Counsel for the taxpayer, and it says the transactions to be compared are the actual transaction. So this is obviously because that's a taxpayer transaction, right? A $4 billion loan by LLC to LLC 5, and the hypothetical transaction, a $4 billion loan by an independent lender to LLC, having regard to covenants which such an independent lender would have required. Now, covenants meaning more or less guarantees or promises, right? And already here you feel something very strange, right? So you need to compare a loan with no guarantees and no promises to a loan with guarantees and promises. And that simply doesn't make sense, but this is what the first tier tribunal went with. And if we look at the covenants that were required, there were two expert witnesses, Mr. Ashley, and he said, you need additional debt covenant restricting the amount of debt that could be raised by LLC 6. Obviously so, because the LLC 6 debt will be paid before LLC 6 could pay a dividend to LLC 5 to pay its debts, right? A provision of additional covenants, e.g. preference share payment covenant from LLC 6 that it will pay dividends to LLC 5, restrictions on LLC 6 ability to lend cash up to LLC 4 because that would just bypass LLC 5, a creation of an intercompany loan balance such that LLC 5 could call a loan for a loan repayment if LLC 6 board failed to declare a preference dividend, provisions for a cash reserve or liquidity facility covering 12 months of interest payments for LLC 5, so LLC 5 can pay LLC 4, and change of control agreements because that's what you commonly have, and a negative pledge restrictions on LLC 5 and LLC 6 from granting security to other lenders because LLC 5 wanted to be the first and only secure party. Mr. Ashley said if you had these covenants in place, then a independent party would have lent $4 billion to LLC 5. And then Mr. Graceford, a economist, Mr. Ashley was a deal maker, and he actually was active in the financial industry. Mr. Graceford was an economist. Said, you need a set of covenants from LLC 6 on the specific conditions that determine the payout of the preference shares so that LLC 5 knew that it was going to get the dividends. The combined effect of these conditions has to be to remove the existing uncertainty and enable the independent lender to form a view of risk. When will I get my money so I can pay my interest? A set of covenants from LLC 6 that it will not take any actions that would reduce the value of LLC 5, such as, for instance, make bad business decisions, take extra loans and interest that it can't pay, etc., etc. And a set of covenants from LLC 4 that it would not take any actions that could reduce the value of LLC 5, because LLC 4 was still the shareholder of LLC 5. So these were the covenants, and what the first tier tribunal judge said, if we only had these covenants in place, then a third party would have lent LLC 5 $4 billion, and therefore we think that this is a commercially rational transaction at arm's length, right? Mr. Ashley, but Mr. Graceford did not agree with this analysis. While Mr. Ashley considered that such covenants would be given, Mr. Graceford was of the view that not only it would be complex and costly to obtain these covenants, but that because it would not be at arm's length. And indeed, Mr. Ashley agreed that the cost of borrowing would have been 40 million lower if the 4 billion had been lent to BlackRock Inc. rather than to LLC 5. So this whole structure had a ticket of $40 million in extra costs, lawyers' fees, banks' fees, and all those kinds of things. On the other hand, if you could deduct interest for $1 billion in the UK, which was not taxed anywhere else, that is, of course, many, many times bigger than the 40 million in additional costs. But so Graceford did not believe that there would have been that the covenants would have been an arm's length transaction. Ashley did, and the FTT followed Mr. Ashley. And then we get to the upper tier tribunal, and HMRC appealed the case because they lost before the first tier tribunal, and the upper tier tribunal explained that there are two issues here. One is a transfer pricing issue, which determines whether any loan relationship debits arise at all, right? The unallowable purpose issue determines whether debits would arise, which would otherwise be brought into account or to be disallowed. Both issues need to be determined separately. So you have the TP issue, whether there would be any loan at all, because the third party wouldn't have accepted loan, and then you've got the unallowable purpose issue, which determine even if there was a loan, whether that still might not have been allowed to deductible interest because the purpose of the loan was unallowable. And the court then starts by looking at what the first tier tribunal said. It said, as to the transfer pricing issue, that although an independent party would not have entered into the loan, this is what the first tier tribunal said, right? It would have entered into the loan if certain covenants had been given. So the FTT starts by saying, under these conditions, no one would extend a loan. But if there were certain covenants, then it would have. And then it says, so the taxpayer wins, which is a strange decision. And then it went on to say, as for the unallowable purpose issue, a main purpose of LLC 5 was to secure a tax advantage. Everyone was very clear about that, and EY wrote about it and everything, right? I mean, also, if you look at the structure, it'll be hard to argue that there was no tax advantage, although the taxpayer does try it later on. And then, in addition, LLC 5 entered into loans in the furtherance of commercial business purpose because it wanted to buy Barclays, right? And that LLC would have entered into loans for commercial purposes even if there had been no tax advantage. And what they argued here was, even if the interest was deductible, LLC 5 had no basis which it could offset against that interest. It had to give away under BlackRock group rules the interest to other UK sister companies, so it never got a tax advantage. Therefore, you cannot say that it did it for a tax advantage, which is a clever but I think twisted argument, because remember, we need to apply a single taxpayer approach under transfer pricing and look at the realistically available options for the single taxpayer, not for the benefits of the group. So starting with the TP issue, the UTT then looks at HMRC's ground of appeals, and it says the first ground of appeal was that the FTT erred in law by concluding that while independent hypothetical arm's length enterprise would not have entered into the loans on the same terms, it would have done so if certain covenants had been given. The argument is that the FTT impermissibly altered the economically relevant characteristics by reading covenants from third parties into the arm's length transaction. That was impermissible because these covenants did not exist in the actual transaction. And I totally agree with HMRC's argument here. And then Mr. Edward, which was the barrister for HMRC, said the hypothetical transaction has to be comparable to the actual transaction in terms of its economically relevant characteristics, and therefore it is not permissible to add covenants from third parties. Mr. Award QC submitted that the FTT had effectively reverse engineered a fundamentally different transaction in a wholly different context. So the Upper Tier Tribunal says the hypothetical transaction must be sufficiently comparable with the actual transaction for the purpose of testing it. The 1995, I said, they looked at the older versions of the TPG. The 1995 version of the TPG, which was in force at the time of the transaction, discussed comparability at length. And then it says, what the TPG says about comparability, that indeed the transactions must be comparable, and then you need to go through your 5 comparability factors, including economic circumstances, such as whether there is a guarantee or contractual terms, whether there are, there are 2 reasons why this was not comparable. And then it goes on to say in paragraph 57, risk is of particular significance in a lending transaction and is highly relevant to transfer pricing. See DSG, that's the Dixon's case on captive insurers. It is discussed further in paragraph 123 of the TPG, in the 95 version then, right? And then the court concludes, the Upper Tier Tribunal, we agree with Mr. Award QC imposing third-party covenants into a hypothetical transaction that did not exist in the actual transaction changes the nature of the provision to which it is to be compared. And you can already feel here the Upper Tier Tribunal goes with the court, and they end when they say it is unclear why, they then talk about a completely different issue. They talk about it's unclear why Parliament only chose to rule out guarantees, and neither side was able to explain why the legislation is limited. I mentioned it here for interest sake, not anything else. But the UK legislations did say something about, when there are guarantees in a transaction, in some circumstances it cannot be a parent guarantee because it becomes a circular transaction. But they only mentioned guarantees. They didn't mention covenants. So what the court then said is, you could very easily circumvent this guarantee rules by simply using a covenant instead of a guarantee. They agreed with the taxpayer, and the taxpayer said, if that's allowed, then why is this not allowed? And the court said, well, this is clearly a loophole in the law, and maybe the government should fix it. And we won't discuss that further. And then the Upper Tier Tribunal conclusion on the ground. One is that the FTT did indeed err in law in permitting new third-party governance absent from the actual transaction. The FTT would have been bound to conclude that no provision would have been made as between independent enterprise because there was no covenant, right? Therefore, we are satisfied the FTT erred in law in a material manner and its decision should be set aside. And here, HMRC already won, right? But the court then goes on to say, in light of our discussion on the first ground, the remaining grounds of appeal are no longer material, but we address them out of respect to the written and oral arguments we received. So the court says, HMRC, you already won, but we will go and look at the rest of everyone's arguments because you took so much time and trouble making them. So let's see what they say, because there are interesting points made there.